Welcome to the RGCS debate with Chiara Cordelli and Richard Garnett debating Must Churches Be Democratic? Held on Thursday, March 25th, 2021. The recording of the introductions and the first few minutes of this event malfunctioned. In place of those few minutes, the content of the introductions and beginning of Professor Cordelli's presentation will appear on these slides. The Research Group on Constitutional Studies is a unit of the Jan P. Lind Center for the Study of Freedom and Global Orders in the Ancient and Modern Worlds at McGill University, focusing on political and constitutional theory, political and legal philosophy, and constitutional level empirical political science. The RGCS lecture series and debates, supported in part by grants from the John Dobson Foundation and the Institute for Liberal Studies, asks leading scholars to come to McGill and present ideas from their research in a way that is broadly accessible to our intellectual community, including undergraduate students. Its theme is the values, institutions, and principles of a free society. Chiara Cordelli is an associate professor in the Department of Political Science and the college at the University of Chicago. She is the author of The Privatized State, co-editor of Philanthropy in Democratic Societies, and author of articles in Ethics, the Journal of Political Philosophy, Journal of Politics, Political Theory, Political Studies, British Journal of Political Science, and Critical Review of Social and Political Philosophy. Cordelli earned her BA in philosophy from the University of Rome, La Sapienza, and her PhD in political philosophy from University College London. Richard Garnett is Paul J. Searle Fort Howard Corporation Professor of Law, concurrent Professor of Political Science, and Director of the Program on Church, State, and Society at the University of Notre Dame. He's a leading scholar of US constitutional law with respect to religious liberty. He clerked for the late Chief Justice of the United States, William H. Rehnquist, during the court's 1996 term, and also for the late Chief Judge of the United States Courts of Appeal for the Eighth Circuit, Richard S. Arnold. He earned his JD from Yale Law School and his BA from Duke University. The slides that follow this are the beginning of Chiara Cordelli's introductory remarks in the debate. Must churches be democratic? The question: 1. Would it be unjust for churches to fail to democratize their internal governance? Unjust. A violation of a right to which a correlative duty is attached. The right to democracy, a claim held by a group of agents to an equal share of power to influence the making of certain decisions, whether through direct participation or representation. If so, should states legally enforce the democratization of churches? The liberal answer would be no and no. A church is a voluntary society of men joining themselves together of their own accord in order to the public worshiping of God in such a manner as they judge acceptable to him. Locke, 1689. Voluntariness, consent sufficient to legitimize church power. Democracy is redundant. Freedom of religion, organizational autonomy. Democratization is wrong. The democratic answer, yes, but. There is a right to democracy within churches, but relevant qualifications would be 1, type of church, 2, constituencies, members, employees, members, religious orders, non-members, etc. And 3, type of decisions. It is sometimes permissible, and it may even be required, for states to enforce the qualified democratization of churches. Why must states be democratic? 1, rules effects, profound, pervasive, and ongoing. Arneson, 1993. 2, rules bindingness. State rules are authoritative and backed by the threat of sanctions. Kolodny, 2014, Narveson, 1992. Coercion. States can enforce their rules coercively, forcing citizens to do what they would not otherwise do. 4, final authority. States have the last word about which rules should bind. Kolodny, 2014. 5, lack of voluntariness, no consent at entrance and costly exit. Voluntary submission cannot legitimize the autonomy infringing and dominating power of state.
And no police. But I think this fact is true, but it is irrelevant. For coercion is not a necessary condition to trigger a case for democratic rights. Because imagine a society, for example, where the civic ethos is so strong that you do not need a coercive apparatus to enforce a system of taxation over the citizens. We may still think that, however, insofar as the taxation system is binding, still citizens should have a right to democratically participating in sanctioning, right, that system, the taxation system. So here it seems that is the finally binding character of rules rather than the coercive nature that matters for democracy. And so one could object, well, churches have no final authority. But then we should ask, why does it matter if the church has final authority or not, in terms of determining whether churches should be democratized? And the reason, I think, is that the fact that churches lack final authority means that their decision can be in principle regulated by a higher authority, the state. And insofar as those subject to church rules are also citizens of a democratic state that is responsible for regulating the conduct of churches, then whatever decision churches make, it has already been indirectly democratically sanctioned by its citizens. But I think this argument is also unconvincing. First, because, for example, as a consequence of immigration, you might think that many of those subject to church rules are not the same as, right, the citizens that can vote on rules within a state where the church resides. And second, states may have a difficult time establishing and enforcing precise contractual terms to regulate the relationship between a church and those subject to its rule. And this is because, for example, contracts tend to be incomplete, and it is, of course, impossible to anticipate all problems that may arise in the future. So the result is that churches are therefore left with wide discretion to decide on what rules to impose on those subject to them. And democracy at the political level may not be enough to legitimize this discretion. But one could still argue, right, that as long as individuals can exit their church without losing access to the basic condition of autonomy, that should suffice to legitimize whatever discretion the church exercises. The famous sentence, love it or leave it. But I think this argument is also problematic. And in any case, the problem is that exit can be very costly. First, there is something particular about churches that we may say that they have a monopoly over a certain kind of occupation. For example, say a priest of the Roman Catholic Church cannot be reasonably expected to work as a minister for another church. And therefore, exiting a church, at least for members of religious orders, often requires a radical change in the way they earn their livings. And yet the skills that they need for their jobs within the church may not be easily marketable. And all this is just to say that exiting a church can be more costly, right, than exiting a normal business firms, and perhaps more costly than it is for, say, highly skilled migrants to exit a state. So costs can be very high, and we haven't even considered psychological and emotional cost. One second, I lost track. Yes, so then, however, the remaining feature would be like consent. So perhaps the reason why democratizing churches is unnecessary is not that they can be exited, but that their power, however pervasive, can be consented at entrance. But the problem, I take it, is that appealing to consent immediately raises a prior question. What contractual terms can be permissibly offered by a church to its would-be members or employees in the first place? And to see the force of this question, consider, for example, the case of immigrants who decided to move to a foreign state. We tend to think that even if they move voluntarily, the recipient country is not morally permitted to make their entrance conditional on their permanent alienation of political rights. And this is because we may think after a while, in the absence of those rights, subjection to state rules would become dominating. And yet it is unclear why the same reasoning should not apply to churches. But perhaps one could wonder, what if someone, say, a monk or cloister nun really wants to submit to a set of unquestionable and authoritarian rules on religious grounds? And here my answer is that the monk's subjective desires and intentions do not seem to suffice to authorize the church's offer of authoritarian terms in the first place, in the same way in which my wanting to join an authoritarian state does not suffice to authorize the state to offer me authoritarian terms as a condition of entrance. So I take it that if all this reasoning is correct, this provides a strong analogical argument for a qualified pro tanto right to democracy within churches. The right is qualified because restricted only to a certain categories of members. So for example, those whose stakes in churches' decision are very high and for whom exit costs are particularly also high. So members of religious order and employees in large hierarchical and traditional churches are a good candidate for these rights, but less so general members. But the right to democracy I hear defended is merely pro tanto, right? Because in principle, it could be overruled by competing claims. And after all, extended democratic requirements to churches, it could be argued, would be incompatible with churches' right to organizational autonomy, which is a right to autonomously decide, right, about how to regulate one's own internal affairs. And it could be reasonably claimed that this right is quintessential to protect individuals' interests in freedom of association and in living authentically in accordance with one's own religious commitments that are fundamental interests indeed. But I think that to see whether the right to democracy should give away to churches' claim to organizational autonomy, we may first ask whether granting democratic rights would necessarily infringe upon church autonomies. And we cannot answer this question without first determining the appropriate scope of church autonomy, which I think cannot be unbounded. So now, insofar, and here I'm kind of going fast, but to give you a sense of the argument of my reasoning, insofar as a claim to church autonomy is ultimately grounded on a general individual interest in freedom of association, I think that whether religious or non-religious organizations should be granted an autonomy-based claim to be free from the applications of otherwise justified norms depends on whether these norms would violate or not specific commitments that are central to the defining mission of the association in question, in a way that applying those norms would compromise the ability of its members to pursue core commitments through the association. Insofar as the point and purpose of an association is to pursue a certain mission, right, the scope of church autonomy should be tailored to the crucial religious mission of the church. But it follows that whether applying democratic norms to churches would infringe upon their organizational autonomy then ultimately depend on the particular kind of decisions at stake. And not all decisions a church makes, I take it, are connected to its core spiritual mission in the same way, such that making those decisions democratically would impose a serious burden on the church members' interest in pursuing their religious faith. So decisions that could be democratized without infringing on church autonomy, I take it, would include, for example, a church decision about employment compensation, unionization, working conditions of various kinds, pension entitlements, the administration of church property and land, work of arts, assets, and many other non-theological decisions that churches make on a daily basis. So if this is correct, here it's my argument for a qualified right to church democracy. And here I end by saying something about whether the second question, right, if this right is justified, should states enforce the respect of this right, the democratization of churches? And my answer is that states have very strong interest to enforce the respect for these rights because the individual's interest that justifies this right in the first place. But we may also think at the same time that, for example, democracy works better when it is autonomously endorsed, or the states may have reason sometimes to tolerate wrongs, or that a state's moral standing as a legitimate enforcement diminishes if the state is itself authoritarian or as a history of oppressing religious groups. So it might be that all things considered, states has no right to enforce, but I think a particularly strong case for enforcement is when states provide the benefit of incorporation and other public benefits to religious organizations. Thank you.
Thank you. Professor Garnett.
Okay, thank you very much. It is a real privilege to be with you. I'd rather be with you all in beautiful Montreal, where I've enjoyed some great meals with Professor Levy in the past, but this will have to do. I'm very grateful to have had the opportunity to read again Professor Cordelli's 2017, I believe it is, piece on democratizing organized religion, and to look also at her very important new book with Princeton. I should say at the outset that although I have learned a lot from Professor Levy and many other theorists, that I'm not one. I'm just a lawyer, or as they used to say on Saturday Night Live, I'm just a caveman lawyer. Like a lot of lawyers, we dabble in political theory, but I come to this question inescapably through a path of work in American public law. So when I think about the rights of religious institutions, or when I think about the scope of state power over those institutions and their activities, I'm inescapably trapped in thinking of them in legal terms. So hopefully there'll still be some interesting compare and contrast between our remarks. When I first encountered the question, must churches be democratic, I was tempted just to say no, and then leave it at that. Or maybe to add kind of mischievously that it's not clear to me that anything has to be democratic. And then I thought, no, it'd be a better answer to say no, unless God says so, and then of course they must be. And then I thought about it a little more, and I was talking with a friend of mine who is a theorist, and she made the interesting point that asking whether a church must be democratic is a bit like asking whether a football game must be played in a zero gravity chamber, by which she meant, I think, that the question perhaps begins with a bit of a mistake. Churches are simply about something else, and they're not designed in the way that polities are. And then finally, as I was kind of thinking about the question, I thought it'd be fun to have a debate where we flipped it and said, instead of must the church be democratic, if we asked, must the state be theocratic? I'm inclined to answer that latter question no, and I suspect it's shocking, but it might be worth thinking about why the frame of our question, that is, must churches be democratic, that is, why it assumes, as it appears to, that the state has a previously established legitimacy to impose democratization on religious institutions. Well, in any event, the question we actually have ended up on, I think, is more modest than the catchy title of our debate. As I heard Professor Cordelli's explanation and elaboration, and also, again, reviewing her excellent article, I think the claim in front of us is actually a bit more modest. It doesn't seem to me, really, I'm open to correction, that the question we're discussing is whether it is, in some comprehensive or global sense, unjust to fail to fully democratize churches' internal governance or bring their mechanisms into congruence with those mechanisms of the liberal state. Again, Professor Cordelli in her article says as much. She avoids that extreme. But the question ends up being really a more familiar legal one, and that is, what is the scope of the state's regulatory authority over certain activities of religious institutions? I didn't hear in any of Professor Cordelli's introductory discussion any suggestion that the state should be able to require churches to convene councils at which they vote on their doctrines. The claim ends up being quite a bit more modest, that certain stakeholders should perhaps have the ability, when it comes to certain subject matters, to invoke the benefits of otherwise applicable state regulations. Again, I think that claim is a fairly modest one, and I would certainly concede that in some instances, in some cases, with respect to some matters, that some actors within institutions, of course, have the right to invoke the state's regulatory authority, and that the religious institutions may be regulated and are regulated in a wide variety of ways. Nobody disputes, I think, or few do, that a parochial school can be required under health and safety laws to have fire extinguishers in the hallways or smoke detectors on the ceilings. And I think most people agree that sort of health and safety regulations can be applied in the context of the workplace of a religious institution as well as any other. So what exactly then is the space where democratization is allegedly absent, but where it ought to be imposed? And again, we're not really talking, I don't think, about a full-scale right to democracy within churches. Instead, what we're talking about, I think, is whether the state's democratically enacted regulations should be applied rather comprehensively to the activities of a religious institution. That strikes me as a very different question, again, from asking whether the church itself needs to be democratized in its internal governance. You could imagine, after all, a church that was in a thoroughgoing way undemocratic or even anti-democratic, but that was still subject to, let's say, the employment laws of the democratic polity in which it happened to be located. So I guess one question that I would have, both from Professor Cordelli's paper and from her presentation, would have to do with a little bit more specificity of the kinds of matters, at least for me, the distinction between essential and non-essential is a bit too vague. What sorts of matters should state regulatory power be extended to, and to what sorts of matters ought it not to be extended to? Again, I assume that the suggestion being made is not that the state should be able to tell a church what creed to adopt or what moral rules to adopt with respect to certain behavior, or what the liturgy should look like. Although I confess that I would very much welcome the government intervening in the song selection of my home parish here in Indiana and imposing better musical taste. But that's a side issue. That's my own hang-up. Another question that for me emerges out of all this, well, it's not really a question, it's more just revealing a difference in starting point. I don't approach this question by asking how much autonomy ought the state to concede to religious institutions. My starting point is not how much independence in internal governance will the state tolerate by churches with respect to its members. I think I tend to approach it from the other side and to ask, what is the reach of the state's regulatory authority? How far does it reach with respect to what I regard as the distinct polity and jurisdiction that many religious institutions in fact are? I don't think it follows that from the fact that because there are some analogies between churches and governments, and Professor Cordelli identified some of those, I don't think it follows from those analogies that state-imposed regulation of churches necessarily follows. I also don't think the analogies are as strong as my colleague does, but I guess that could be a separate matter. Another word in our question, the question presented to us, was the word must. Must churches be democratic? Now, at the end of the presentation, Professor Cordelli notes that even if one thinks that churches ought to abide by certain norms that are congruent with those of the secular state, and even if one thinks that churches should adjust their internal governance practices to be more democratic, one might still think that this democratization should not be imposed or enforced. Instead, one might think it should just be incentivized. And that raises very interesting questions about tax exemptions and conditions on incorporation rights and other things. But again, just to focus on the terms of our question, must, I think that it's a revealing one, because the term must implies some authority that is going to be doing the enforcing, doing the imposing of this democratization, doing the supervising of it to make sure it's adequate. And again, I just wonder how far Professor Cordelli and perhaps others who agree with her position think that should go. That is, if we subscribe to the position that we have reasons even for a pro tanto extension of democratic norms into the internal lives of churches, what mechanisms, not only as a prudential matter, but what state mechanisms do we think would be legitimate to use in order to bring that about. Another thought, it seems to me that much of the discussion actually isn't about the democratization of churches, but rather it's about the imposition of one democratic majority's enactments, that is the majority in the political community, on perhaps a majority of another one. That is, we might well think that, I assume that Professor Cordelli would say that even if all of the members internal to a religious community democratically decided to adopt certain rules that were inconsistent with the norms of the political authority, that the political authority's norms should nonetheless win out. That is, the democratization of churches could have, it seems to me, the ironic effect of having anti-democratic effects within. So in the time I have left, I just wanted to sort of pose a few questions, not only for Professor Cordelli, but for all of us. One has to do with the nature of a religious vocation. Professor Cordelli referred a number of times to religious sisters or nuns or priests. I know a lot of people by virtue of where I live who are in religious orders, who are in, have taken vows, who are in consecrated states of various kinds. They're not governed democratically, but not one of them, at least in my experience, has ever regarded their decision, their response to the religious vocation that they heard, as having any analogy to the situation that one encounters sometimes in political theory writing, is whether or not one is permitted to enslave oneself. Those priests I know who happen to have taken vows of celibacy, they don't think that what is going on is that they are being prohibited by an authoritarian power from having families. Rather, they think that they have been called to a certain state, and that part of that call has involved making the choice to not have families. They don't view a religious vocation as responding to, I think what Professor Cordelli called an authoritarian bargain. So I wonder if one problem here is if there's just kind of a, as the movie says, a failure to communicate. I wonder if political theorists are fully, in order to evaluate the decisions that people in many religious orders have made, and again, I'm speaking mainly to the Catholic context, it's the one I know best, but obviously there are many other situations. If we need to do a bit more work to kind of understand the internal perspective. Now, Professor Cordelli said their motives don't, for entering into the state don't matter, and I take that point, but I guess I'd want to push still a bit more and ask about whether the Professor Cordelli's argument really takes account of how people in religious orders conceive of what it is they've even done. Relatedly, I mentioned a second ago that I was addressing mainly the Catholic context because it's the one I know best, but I think even when it's not explicit, I think that's the context that's being addressed most in Professor Cordelli's paper and in her talk. And I guess I wonder why, or I wonder how generalizable her argument is to storefront churches in the United States that are vaguely affiliated with the Church of God in Christ. We discussed a little bit the situation of religious sisters or nuns, who obviously nuns are different from religious sisters, but there are many more Buddhist monks in the world than there are Catholic ones. And so I wonder what the argument has to say about that, or is there something particular about the history that we're inhabiting and the particular history of the relationship between the Catholic Church and the state after the French Revolution that is driving the argument? Is it generalizable? Does it apply to mosques, which I assume are governed undemocratically, at least internally? Or is it really a feature, is the argument targeting the special relationship between the Catholic Church and the state, which again, whether one's in Montreal or whether one's in Rome, is a relationship that's obviously been important, to put it mildly, historically. And then I mentioned a second ago, or a little while ago, the distinction between essential and non-essential that Professor Cordelli highlighted, again, the pro tanto right to democratization within churches, I think, is limited to stakeholders of a certain kind, and it's limited to non-essential matters, that is, matters that are not necessary for the religious association to be able to perform its spiritual function. In her article, Professor Cordelli discusses and treats fairly, I think, the objection that that line between essential and non-essential is hard to police. She doesn't think it's that hard to police, I think, and I guess I think that'd be worth talking about a bit more. What criteria will the secular state use to decide which matters are sufficiently non-essential to a religious institution's spiritual mission that it's appropriate for state power to be extended over those? Again, we probably could all agree about smoke detectors and fire extinguishers. But what criteria are we going to use to decide whether or not it's essential to a church's mission to be able to decide, say, who it will or will not hire as a teacher in a religious school, to refer to some of the cases that have come up in the United States context lately. And then finally, for now, in the paper, Professor Cordelli is using churches, she says, as a limiting example, and as part of a broader examination of the appropriate reach of democratization and democratic norms and rights to democratization. And I wondered what we should think about families. To what extent does it follow, if at all, that there is a right to democratization, a state enforceable right to democratization within families, and perhaps on non-essential matters, although I'm not sure exactly what those would be. If it is appropriate for the state to extend the reach of its political authority to the internal workings of a church, then is there a principled reason, or is it a matter of degree to be worked out on a case-by-case basis? But is there a principled reason why that authority would not be extended into, say, families as well? So I will, I'm about up on my 20 minutes here. I'll stop there and again say thank you both to my hosts and to Professor Cordelli, and I'll give it back to Professor Levy to tell us what's next.
Okay, thank you very much. What's next is a round of replies with each of our speakers taking 10 minutes to engage with what the other has said. Professor Cordelli.
So thank you very much, Professor Garnett, for these questions and also for your comments. So starting with just as a clarification, and then I'm answering question by posing more questions, since by all means these are not all questions where I have a 100% definite view. But the reason why I became interested in this topic, among other reasons, was a case that I also read about the Romanian Orthodox Church, where a group of priests claimed the right to form a union, and they were prohibited from doing so. And of course, the church argued that the priests were, religious. They weren't workers, even if actually they were receiving a compensation for precise tasks they were performing, and churches could decide on their relocation, the schedules, work conditions, etc., etc. And so I think this is just to say that, thinking about that case, I thought a certain decision about working condition should be democratized and could be democratized also in the case of religious workers like priests in this case, without necessarily undermine the fundamental mission of the church. And I think actually the European Court on Human Rights precisely formed, a decision around the same kind of argument. So this is just to say that I'm not just invoking state regulatory authority, but I'm trying to make an argument for the extension, at least, for example, to certain forms of workplace democracy within churches that I think would go much beyond just invoking state regulatory authority. And employment condition, however, is just one type of a more general set of decisions that could concern also, as I said, assets, property management. I'm here thinking very much, for example, about how much property and wealth the Vatican owns, right? And who should decide on management and spending of the property. But this raises indeed the question that Professor Garnett was mentioning, which is not only how do we distinguish between what is essential and what is not essential, but also who has the authority to decide. And here, I think that this is really the core and most difficult question. What I would say, is this. First, I think the states cannot avoid making this kind of decision, even only to grant certain special accommodation or exemption to religious organization. For example, they need to decide what counts as a religious organization, whether, for example, a yoga club should be understood as a religious organization or not. And that, it seems to me, would be implausible to think that just the subjective, fully subjective determination of an organization could suffice to justify, certain accommodation and certain exemption. Similarly, think about states deciding on religious ground, freedom of religious ground, to fund the construction of certain religious building of maybe underrepresented religious minorities. Also in that case, in order to distinguish between a religious building that is required on religious ground and a mere preference, the state necessarily has to decide that the religious building is essentially related, right, to the core religious purpose of an organization, and is not just a frivolous preference. And in fact, states do this all the time, courts with no religious association. I think in the JC cases, right, the Supreme Court decided that women could be granted voting rights within an association, the purpose of which was to pursue, to foster certain particular interests of men in professional networking, and it judged that giving voting rights to women did not affect the mission of the association. So there is also here a question of neutrality and of fairness, right? Is religious special? Well, I don't see a reason here why religious associations should be treated as special, at least if compared with other expressive associations. And so the state decides what is essential and not for non-religious association, and so it should also do the same with for religious ones. Let me also say on this point just one further things, and I'm actually kind of losing track of time. But there are cases, for example, again, the unionization cases, where it was unclear, the court said, whether the contract that the priest signed with the church ever prohibited them from unionizing or not. And in these cases of disagreement, where there is no objective written rule, the state, if decides to defer, has to decide to whom within the religious group to defer. And if the decision only, is always the kind of head of the hierarchy, that means that vulnerable minorities within religious groups will never have a voice or a stake in deciding or interpreting what their mission of their association is. So have I run out of time? No? 4 minutes. Okay, great. So this is all to say that the question is very, very difficult, and I'm very far from solving it once and for all, but I still think that there are good reasons for thinking that the determination of what is essential and what is not essential has to be made, and in part in a not fully differential way, and it cannot simply depend by what some members of organization purely subjectively decide that their mission is about. So perhaps the courts have to look, of course, at the coherent narrative of an organization, their written documents, their history, and some, objective, more objective, ways of determining what is essential and what is not. Again, the nature of religious vocation, at the cost of repeating myself, I think that although it's very important for many reasons to think about, the fact that a vocation is not the same as other ways of making choices, I still think that it is in part irrelevant for the purpose of what I was trying to argue for. And to perhaps make the argument a little bit stronger, let's take other non-religious case of employment. So suppose that for all of you, your job is not a job, but it's a great pleasure, just because you have the fortune to really enjoy your job. And so it's perhaps a vocation, but that doesn't seem to me to change the fact that your employer should treat you in certain way. So the fact that people join an organization, whether for employment, for other reasons, on the basis of vocational dispositions, does not authorize the employers not to do certain things that would be otherwise required. And perhaps, I want to also end perhaps with a question to Professor Garnett, because I know that having read his work, he has a view about state fundings. Generally, the view, and a view that I also defended in my talk, is that at least when state fundings of religious group are at stake, then the state at that point really is required and has a right to extend certain demanding norms, whether anti-discrimination norms and perhaps even democratic norms, to certain groups. But Professor Garnett thinks that actually that's not the case, that receipt of fundings, and I assume also, for example, the benefits of incorporation, are not per se sufficient to legitimize state actions in terms of, again, extended required norms to churches. And so I would like to also ask him perhaps to say something more about that. Thank you.
Okay, great. Do I go, Jacob, now?
You do. In the interest of getting some disagreements a little bit sharper, I'm going to make a 1-minute intervention before we move on to your remarks. Professor Cordelli's last segment made reference both to questions of the determination of church property, that is, who has the authority to decide how, as it were, the Vatican's wealth should be disposed of, and the possibility of state recognition of dissidents as being relevantly church authorities. I think giving rise to the possibility that the question the two of you are debating is a bit starker than some of the initial exchanges suggested, we might imagine on this account that the state would sometimes recognize a democratically self-elected group of dissidents as being the legitimate determinants of control over church property, which is something significantly more dramatic than a question like ordinary employment law for non-clerical employees. And with that, I'll hand the microphone over.
Great. Great minds think alike, and ours do too, Jacob. I wanted to address some of that. Let me just proceed to that, though. First, I want to agree entirely with the point that even though you called for sharper disagreement, I do want to agree with the point that was made by Professor Cordelli that, of course, it is inescapable in a regime that takes cognizance of religion in any way for the secular authority to avoid making some categorization decisions or boundary determinations, and is going to have to make decisions about what counts as a religion, what's not, what counts as a religious belief, what doesn't. We see this, I apologize for being parochial, in the context of American religious accommodations law all the time, where under our law, much to the chagrin of some, the free exercise, the First Amendment's free exercise clause protects, to the extent it does, religious beliefs and not conscientious or deeply held beliefs of all kinds. And I realize this is different from many other jurisdictions. Our tax law gives exemptions to many religious institutions, and in order to do so, it has to identify those entities as religious. If in order to protect the free exercise of religion, one has to identify what it is one's protecting. So I take that point, and yet I still want to insist that we are appropriately nervous about inviting courts to make a particular kind of internal decision about what sort of matters within a religious context are important to the religion and which ones aren't. It strikes me that we can take a more kind of sociological external point of view when we're classifying entities for tax exemption purposes, but it strikes me as a different thing to for the state to decide whether or not a particular extension of regulatory authority, and with all due respect, even the union example that we started with does involve the extension of regulatory authority, to decide whether that affects or does not, is essential or inessential to the religious mission, seems dangerous. On the question that Professor Cordelli ended with on funding, so it is true as a descriptive matter that when the government spends money, it regularly attaches conditions to that money. We see this all the time in the American context, and I assume in other ones as well. And this is true not only of spending, it's true of incorporation, as Professor Cordelli pointed out. It's true of things like accreditation, grant making, licensing. We're seeing this in the big Supreme Court case in the US right now out of Philadelphia. The question has to do with the conditions that are attached to a licensing regime. It is my view, as you heard, that the government ought not to use the leverage that spending affords to interfere with not only the religious freedom rights of religious institutions, such as religious schools or religious hospitals, but also just with the rights of expressive associations generally. I do think that churches are distinct from expressive associations generally, but I think here the point can be made with respect to both. Third, and I will get to your point, Jacob, Professor Cordelli suggested that there's nothing distinctive or special about the problems that might be presented by, on the one hand, government interference with, say, the practices of the JCs, which is a commercial club for business people, used to be businessmen, but there was a Supreme Court case about this, a unanimous one, on the one hand. And then on the other hand, government intervention in the internal affairs of churches, including, I take it, some internal affairs that really do go directly to some religious questions. And there, I guess I can only say that for at least two reasons. One is just historical. It seems to me that church-state relations in the Western tradition are just different from state relations with voluntary associations of business people. And then second, at least in the American context, we have an establishment clause which has been interpreted for a long time as requiring a certain kind of separation that's not required in the context of the JCs or other forms of voluntary associations. That is, at least in the American context, there are special reasons and special requirements that the government stay its hand and worry more about intruding in the internal affairs of religious institutions, because that could entangle government in theological matters, which has, historically is a concern, at least that our court has had. Finally, to Jacob's point about church property, this is fascinating. As some of you might know, there is a roiling debate among American church-state scholars about how these breakup cases of religious congregations should be handled. This is happening with some frequency, where a congregation splits up, and then the question is, who owns the property? Sometimes it's said that, well, we can decide these cases in a fairly straightforward way if it's a certain kind of church, a congregational church that is organized democratically. They can just take a vote and the majority gets to keep the property and the minority has to buy a new building. That doesn't, in such a circumstance, I don't think the government is really required to interfere much with theological questions. But where these things get difficult is, Jacob, as you pointed out, when you have dissident groups or dissenting groups, or Professor Cordelli put it, vulnerable minorities within larger religious communities who are asserting a claim on property against the juridical authority, the religious authority of the religious community in question. My view is, it's consistent with Supreme Court cases going back 150 years, is that it makes good sense for secular courts to, when they're dealing with property disputes within so-called hierarchical churches that do have kind of an established juridical structure, it makes sense for courts to defer to that, just as it makes sense for the court, for a federal court, to defer to the Supreme Court of California when it comes to interpreting California law. But a number of outstanding law and religion scholars whom I admire very much, such as Michael McConnell, have argued that American law in this respect should change, and that all property disputes arising within churches should be decided in a sense in a religion blind way, that is using only ordinary doctrines of contract and property law, and essentially put the burden on religious institutions, including hierarchical ones, to organize the ownership of their properties in such a way that will work for them. My own view is that would be a mistake, that would risk entanglement between religious and political authorities, and also that it would impose unfair costs on some religious communities over others. But that is a debate that's going on in American law right now. And then finally, I take Professor Cordelli's point that many of us feel called to the jobs that we're in, regardless of whether we're working for a religious institution or not. And the fact that I feel called to work for Google doesn't mean that Google can treat me badly. Google seems to have no trouble treating people badly. But I guess I want to still stick a bit more on the idea that for those who experience a distinctly religious vocation, the approach that Professor Cordelli is sketching, I think, would have the unintended and unfortunate consequence of closing off a certain kind of life choice that, at least in my view, has value and that the state need not oppose. I mean, the option needs to be there, it seems to me, or at least historically we've always thought that it could be there, for people to be willing to enter into a cloistered monastery in which they're not governed democratically. This isn't a question, again, of an unjust contract of adhesion where an immigrant comes to a new country and is told that a condition of presence is that one waives democratic rights going forward. I just don't think that analogy works. And again, at least in my view, it would be a loss if we adopted a legal approach that had the effect of making it very difficult, if not impossible, for people to enter into the religious state that has characterized a number of religious communities for a long time. So 9 minutes and 40 seconds. Sorry, Jacob.
Perfect. Okay. And Professor Cordelli, final remarks of less than 5.
Thank you. So thank you. Let me actually, I wanted to first start with a remark about a question that Professor Garnett raised in his previous comment, which asked me whether my view was influenced or shaped by perhaps the Catholic Church or limited to the Catholic churches. And I think that's definitely true, but there is a non-coincidental reason for that. I mean, there might be a biographical one, given the fact that I grew up in a city that was the residence for the Pope for 25 years in the 13th century. But beyond that, I think the reason is that, of course, certain traditional hierarchical churches, including, of course, first of all, the Catholic churches, all of you those of you who read Leviathan well know, also for example, the Orthodox Church are churches that have historically had competing claim to sovereignty. And so it is not a coincidence that they feature certain properties that are normatively relevant, I think, to make a case for democracy, and are the same property that share in many respects with states. So it's not, in that sense, no coincidental. Let me say something about tax exemption, because actually, I think the issues of funding is very important, but here I think I disagree, at least in one fundamental respect. So the fundamental question is a state ever justified, right, to fund and give fundings to religious groups? And I think if you're committed to a certain kind, at least, of liberal neutrality, the answer would be yes, but only if there are no religious reasons for doing that, like reasons of a public nature. One of these could be the promotion of pluralism in society. I've always found that reason unconvincing as a reason to fund associations. But I could see if that's your reason, but as I said, I find it unconvincing, that you shouldn't link, the state shouldn't attach very heavy regulatory burdens to funding if the reason for the funding is to promote, right, pluralism of a certain kind. But I think the reasons often states fund association, and I think also one of the reasons that Professor Garnett mentioned also in his work, is that states wants to use associations to provide services on its behalf. But if that's the case, it seems to me the religious group is called to act on behalf of citizens, as if it was an agent of the state. And at that point, I don't see a reasons for why one should give that kind of funding for an association without requiring the association to abide to certain justice demanded norms. So I just wanted to mention that I think fundamentally here is the reasons for why funding can be justified in the first place. Third point, I think I say religion is special, Professor Garnett says, because because otherwise, if religious wasn't treated as special, government would get entangled in theological questions. But again, this begs the question of why theological questions are special. And there I think that there are, both in terms of epistemic reasons or other ways of thinking why theological questions are special, I'm not really clear why they should be treated as special compared to, say, metaphysical question that philosophical association address, or other kind of questions, right, that refer to the ultimate meaning of life that might be addressed by all sorts of kinds of expressive and other kind of association. And on Professor Levy's question on property, here I think that compared to Professor Garnett, I'm less keen to give so much deference to group precisely because that would undermine vulnerable groups, as I said, within churches. But I have to say at the same time that my approach does not provide a substantive answer, right, to the question of property. I'm not saying that the vulnerable groups should manage property and the dominant group should not. I'm saying that perhaps the most neutral way actually to solving that conflict in the absence of alternatives is precisely to a democratic procedure. So that's a further argument for, in some sense, democratization of churches. Thank you.
And Professor Garnett. You're muted.
I didn't realize I was going to get more time. That's great. Okay, so just on two things very quickly. On the special point, I realize it's a very pedestrian and prosaic response, but at least in the context of the United States, my view is that our Establishment Clause provides a distinctive reason for being more worried about government entanglement with religious questions than with normative questions generally, or with questions that might have some moral dimension, such as the ones that were at issue in the JC's case. I take your point that it's often going to be the case that religious questions, whatever we mean by that, are not necessarily more complicated or more vague than questions about other ultimate matters. But again, at least in American law, we have a distinctive constitutionally grounded reason for wanting to operationalize this sense of separation by keeping the government with particular care out of religious questions. And then on conditions, I like the way you categorize the two reasons for public funding of religious institutions. You can think of we could add a third, I suppose, which would be kind of in established church context. The government simply regards it as part of its job to maintain the established church. I don't think that's what either of us is talking about, but I do think that it's a good thing for the government to use and to support and to facilitate the operations of non-state associations in all kinds of contexts. This is the pluralism rationale. And so I agree with you that when the government is funding non-state institutions, it should do so with an eye toward not interfering with pluralism. But then you identified another rationale, which is sometimes just service delivery. And you know, my view would be that when the government is, in a sense, contracting with a religious entity to do some service for the government, it's perfectly appropriate for the government to have some strings to make sure that the service for which it is contracting is actually being provided. So I'm a strong supporter of public funding for parents who send their children to religious schools. We call it school choice in the States. I realize in Canada this is much more common. And it seems to me that it's perfectly appropriate for the state to say something like a school that receives public funding through a school choice mechanism does have to provide some evidence that, you know, children are achieving basic competencies and so on. I would oppose using that funding, though, in kind of an ideologically leveraging way, in a way that went beyond making sure that the state's interest in education was accomplished, and instead tried to impose this congruence on the religious institutions from top to bottom that I think is unnecessary. So if anybody's interested, my colleague at Notre Dame Law School, Randy Kozel, Kozel, has a law review article out. And obviously law review articles mean there's too many footnotes, but it's still good. It's called Leverage. And it's about all the areas in which, in American First Amendment law in particular, public funds and licensing and other sorts of things are used in kind of a soft power sort of way, in ways that can burden what we might think of as First Amendment rights. So I like to associate myself generally with his view that kind of leveraging is worrisome.
Okay, thank you very much to both of you. At the RGCS events, the first question is reserved to a member of the Research Group on Constitutional Studies Student Fellowship. The floor is open to a member of the fellowship. And if one doesn't come quickly, then I'm going to proceed with announcements to let you gather your thoughts. Okay, student fellows, please gather your thoughts for a question. This is the last of the in-term semester events for the RGCS Lecture and Debate Series. 2 weeks from today is the Jan P. Lind Center's annual lecture, which will be given by Professor Bruno Latour from Sciences Po on the topic From One Lockdown to the Next, A Change in Cosmologies. And Professor Latour's lecture is a Highlight McGill Bicentennial event, and in conjunction with it, there will be both an additional talk on Friday, on the day following, and a reading group the week after. Information on those events is available on the Lind Center's website. There will be one more event in the RGCS Lecture Series after the term ends. Professor Melissa Schwartzberg from New York University Law School will give an RGCS lecture on April 29th in this time slot, in conjunction with the RGCS year-end conference on constitutionalism and a free society. There isn't yet information on the RGCS on that conference online, but there will be soon. we now have 2 hands up, so I'm going to proceed to questions, and then I will do the book giveaway after we get through 2 questions. Nessie.
Hi, thank you. So my question is to Professor Cordelli. I guess neither of you got really into the definition of democracy that you're working with. So I'm wondering, to what extent does this democracy of churches that you talk about include majority rule alone, or also minority protection in some sense? So kind of going back to some of the arguments that were raised, if a majority of the church decides something that in a democratic polity could be considered a violation of the minority's rights, then how would that function within a church context? Yeah.
Yeah, so thank you. This is a great question and a difficult one. And I have to say that in the paper, I sort of intentionally left that under the term in the sense that even the conditions that I take it as jointly sufficient and perhaps individually necessary to ground the right to democracy ultimately depends on your particular theory of democracy, which of those conditions would matter in which ways. But personally, if you are sympathetic as I am to a broadly, let's say, Republican view of the grounding of the authority of democracy, then I think that although, a value like Kantian freedom as independent or Republican non-dominations ground, a right to a democratic system founded on majority rules, that same values can also, I think, be appealed to justify anti-majoritarian measure when necessarily to prevent the formation of permanent minorities. So in the case of the church, how would that apply? First of all, I think it would depend on a series of empirical reasons, right? We would need first to ask empirically whether there is within a church the same risk of formation of the same permanent minorities as there is in, say, in a pluralistic political society, and probably the answer, would be yes. And if that's the case, we would need to, perhaps justifies anti-majoritarian measures, but then of course this is all comes from an argument for a pro tanto right to democracy, and so we would then need to ensure then doing that is compatible, however, with the theological and fundamental religious mission of the church. But in principle, I don't see a reason against anti.
Nessie, you said much more efficiently than I did. One of the things I was trying to say, which I guess is that I took the argument at the end of the day to be more about applying democratically enacted state rules to churches than I did to take it about being imposing or arranging or requiring democratic decision-making within a church.
Verity.
Hi, my question is more directed to Professor Garnett, although both could weigh in. Professor Garnett, you said in response to something Professor Cordelli said, that the state can sort of hand out funding to churches with strings attached, but that you didn't think that should be used for ideological imposition. And I was just wondering if you could expand on that a bit and tell me like really where that line is, or even what the distinction is. Because to me, it seems like a very fluid distinction in what one person might call ideology, another might not. I wanted to give 2 examples from Canada. The federal government gives out grants for summer student jobs. And a couple of years ago, any organization that took one needed to sign something saying they agreed with a woman's right to choose, like in an abortion context, and a lot of churches got very mad and refused to take that funding. And now I've already forgotten my second example, but for example, funding. Oh, I was thinking about your church school example, where if the basic requirement that a government gives is, that evolution needs to be taught, because that's like a basic understanding of how the world works, or that the general Western world has agreed on. And if you would say both of those are ideology, or to me, there's a distinction there, but maybe to you there isn't. And yeah, that's my question. Sorry.
Yeah, that's a great question, and one that I sort of always hope that students will forget to ask, because I don't have a neat and good answer to it, but you're entirely right to press me on it. I think, and I might get in trouble with some people with whom I generally agree, I think that conditioning the receipt of public funds on the adequate instruction of, say, basic facts of science is appropriate, and I think that would extend to at least scientific questions about human origins. I probably, and this is kind of a dodge, but I probably wouldn't, I definitely wouldn't condition the legal right, say, to homeschool on that. I think parents should have a very broad right to do that. But in the context where there's funding, I would think that would be an appropriate string. It strikes me, though, that requiring the recipient of public funds just to kind of like wave the flag and assert their support for abortion rights seems kind of a gratuitous ideological leveraging to me. But I don't have a bright line. One place to start, this is not going to be a complete answer, but one place to start is Justice O'Connor, in a case from the 1980s in the US Supreme Court called South Dakota versus Dole, suggested that when we're trying to find the limits on the conditions that the government's allowed to attach to money, we should be asking whether the condition in question has to do with the use for which the funding is being allocated. Now, again, that seems pretty obvious. This case had to do with highway funds, and they were leveraging it into changing the drinking age, and she thought that was a unrelated condition. I'm inclined to agree. I think, in my view anyway, the abortion example you gave for summer funding strikes me as being similarly irrelevant, might be too strong a word, but kind of sidelined. So I think that's a question that I don't have a perfect answer to. Maybe it's kind of like the debate about finding the line between essential and non-essential. We're still working on it.
Before we proceed to the next question, I'm going to randomly select a registered student for the book giveaway of Professor Cordelli's book, The Privatized State. Getting to my list of students, and with my dice in hand, number 16 is Anna Tse. Anna, are you still here?
Yes, thanks.
Okay.
That's awesome. I'm really excited to read the book.
Jacob, did you use 20-sided Dungeon Dragon dice for that?
I used a D4 for the first digit and a D10 for the second digit. Okay, and Nina Arendt will be in touch with you about getting you your copy of the book. Jordan Walters is next.
Great. Well, thank you so much for both being here. It's been a pleasure to, listen, and it's very engaging. So perhaps this question is directed at Professor Garnett, but, I'd be happy to hear anyone chime in on this. So I think if I understand you correctly, you think that the question that we're talking about today, must churches be democratic? We should understand that as whether the state should impose restrictions on churches via labor law, et cetera, and so on. So here I'm, and this is partly just because I'm interested in this, I'm inclined to draw on this debate about workplace democracy, and perhaps understand the question as, just as some think that workers should have some voice in a firm, maybe we should think that various associational groups like churches should be democratic with respect to a given set of strong interests. And I think that this is separate from the top-down imposition of labor law, because this sort of polycentric method of governance allows that some firms be more restrictive than others due to various members' interests, and then vice versa, some might wish to be less restrictive. And so the question I have here is, does this method of giving greater voice to members of various churches fare better than top-down solutions, wherein, like you say, a democratic majority imposes its rule over another? So if so, why? And if not, why not? So I'd just be glad to hear you comment on that.
Yeah, and I apologize in advance if this isn't responsive. I guess I regard your example of kind of workplace democracy and so on as still involving in some way the application, maybe imposition is too strong a word, but still the application of the secular state's law. That is, presumably those workplace democracy chosen arrangements would be litigated or enforced in some contexts, and the government would be asked to enforce them. Now, if you're asking an interesting question about kind of like church polity and should they be democratic or should they not, that strikes me as a really interesting religious question, right? There is a long tradition of some Protestant congregations being aggressively democratic in their internal governance and doing so for theological reasons. And of course, the Catholic Church is not democratic, not because of anti-democracy, but because we sort of think that God told us how the church was going to be set up and governed, and because of what the church is. It strikes me that it's just, it's an apples and oranges problem when we start assimilating churches to voluntary associations for purpose of this question. Because it seems to me anyway, the question of how should or how ought a non-state entity to be governed and structured internally, that question is always going to have to be answered, it seems to me, first from the internal point of view. And when you're talking about churches, there's God involved. And I'm a little reluctant to say, well, it's just like the JCs. I know that's not satisfactory though.
All right, with apologies to the three people who are waiting in line for questions and who under normal, better circumstances would be able to approach the speakers in the open bar reception that would immediately follow. We are at 6 o'clock and our speakers need a 15-minute break before they reconvene with the members of the Student Fellowship at 6:15 at the other link that everyone should have in your email. So with that, we conclude the semester's RGCS events, and please join me in very warmly thanking Richard Garnett and Chiara Cordelli. Thank you, everyone. Hope to see you in 2 weeks at the Lynn Center's annual lecture from Bernard Latour.